Hello everyone, welcome to CashcroftTV. My name is Kalen Ashcroft. Thank you very much for watching this video on Guide to Legal History and Historians, where we will be going through each chapter and respective author of the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins. Today we will be covering chapters 37, The Transformations of the Common Law, Modernism, History, and the Turn to Process by Kunal M. Parker, and Tracing Legal History in Continental Civil Law by Heikki Pihlajamäki from Finland. And these chapters, I think, are two very representative chapters of the history of common law and history of civil law, so I think they run perfectly together as a pair. It was coincidental as I was doing in pairs of two in the style of Plutarch's Lives, so it's very nice that the two respective chapters in Part 4, Traditions Tracing Legal History, come together. Common law and civil law, the two largest legal traditions. Furthermore, this video and lecture will be styled in the style of Plutarch's Parallel Lives, so I will do a brief biography of both authors, and at the end I will have a brief comparison of the two to learn a little bit more about their different academic work and different past and such, and perhaps learn a little bit more about their two respective outputs. So without further ado, we will begin with the chapter by Kunal M. Parker on common law. So this chapter is in Part 4, Traditions Tracing Legal History in the Oxford Handbook of Legal History. It is chapter 37, titled The Transformations of the Common Law, Modernism, History, and the Turn to Process by Kunal M. Parker. So starting with a brief biography about Kunal M. Parker. So he is the professor and Dean's Distinguished Scholar at the University of Miami School of Law. He has a PhD in history from Princeton University, a Juris Doctor and Bachelor of Arts from Harvard Law School and Harvard University, respectively. He also spent a few years at Dartmouth College before switching to Harvard for his bachelor's. His teaching interests include property, estates and trusts, constitutional law, American legal history, immigration and nationality law, comparative legal history, politico-legal theories of empire, race and law, conflicts of law. He joined the University of Miami School of Law in 2009 as a professor. After he was from 2007 to 2009 as the James A. Distinguished Professor of Law at Cleveland Marshall College of Law in Cleveland State University in, of course, Cleveland, Ohio. His fellowships include at the National Humanities Center at the New York University Law School, as well as the William Nelson Cromwell Foundation at Cornell Law School, and at the American Bar Foundation, and as well he was a visiting scholar at Queen's University in Belfast in Northern Ireland in the United Kingdom. His first book was titled Common Law, or is titled Common Law, History and Democracy in America, 1790 to 1900, Legal Thought Before Modernism, published by the Cambridge University Press in 2011. His second and most recent book is titled Making Foreigners, Immigration and Citizenship Law in America, published by the Cambridge University Press in 2015. He has over 31 articles, contributions to books, and published essays, including this chapter, plus countless papers and a very large selection of book reviews on a range of topics. He has been admitted to the New York Bar in the Second Department in 1995, and he speaks, or his languages include, French, German, Hindi, Marathi, and Spanish, so a polyglot as well. So, without further ado, we will discuss him more in the comparison with Pihlajamäki, but we will move to his chapter, titled The Transformations of Common Law, Modernism, History, and the Turn to Process, or essentially our legal history of common law in the Oxford Handbook of Legal History. So he opens up with a thanks. He would say he would like to thank the audiences at Columbia Law School, Cornell Law School, and the Florida International University School of Law for their reactions to an earlier version of the chapter. So starting with his introduction, he references in 1921 the Carter Professor of Jurisprudence at Harvard Law School, Roscoe Pound, curiously stated, "We have come to believe in conscious lawmaking, perhaps indeed to have too much faith in what we may have achieved thereby," in his The Spirit of Common Law, published in 1921, which is likely a reference to The Spirit of Law by Montesquieu, which I actually happen to have a copy here, and I'm almost finished as well. Great, fantastic book, but not necessarily a direct parallel to The Spirit of Common Law by Roscoe Pound in 1921. So he notes, what did Pound mean by conscious lawmaking as opposed to unconscious lawmaking? He states, the author of this chapter states that it hints at the historic shift from the latter, unconscious lawmaking, but it also notes a stroke of caution in that it is possible to have too much faith in conscious lawmaking. This chapter, according to the author, will trace the transformation of American common law between the 19th and 20th century, with Pound's statement being typical of the early 20th century legal attitudes. For many believe unconscious lawmaking repudiated in favor of legislative and administrative conscious lawmaking. So this shift in common law, particularly in the United States, but perhaps likely true throughout all common law countries. And as well, the massive change in the ways American legal thinkers conceived of a place for common law, and indeed law itself in the American polity. He notes that Pound's fear that Americans might have too much faith in conscious lawmaking might have been exaggerated, and the unconscious may never have gone quite away. So perhaps Roscoe Pound was too strong in his statement, but nonetheless quite prophetic. So to proceed in this chapter, we will draw attention to the nature of the profound intellectual shift brought about by the late 19th century and the far-reaching transformation dubbed Modernism that spread across the North American world at that time. And it took different forms depending on national, linguistic, and disciplinary contexts, though nevertheless it impacted a range of fields from science to painting, mathematics to music, and of course to law and as well literature. The department from point will be Peter Gay's working definition of modernism, in that modernism was far easier to exemplify than to define, with two features, the lure of heresy and the commitment to principled self-scrutiny. The author will argue both instantiated through a turn to new conception of history. So nonetheless, although modernism might be difficult to describe, it'll be a basis point for describing this change in common law and nonetheless tracing the legal history of common law itself. Following the American Revolution until the 19th century, we'll continue to show that the American state was relatively undeveloped and common law played a critical role in American polity. Judges declared law for the community through step-by-step gradualist lawmaking, which balanced both continuity and change, and the significant role was not inconsistent with the democratic project at the time. Therefore, in a world replete with foundational and teleological thinking, knowledge that he coins, the constraint of judge-made common law on democratic self-making was one constraint among many. So there was a necessity to have a strong judiciary that kind of knew the facts and kind of held back the polity. And therefore, with modernist sensibility, however, and growth among the post-Civil War state, anti-foundational thinkers such as Oliver Wendell Holmes Jr. began to chip away at the long-accepted foundations, and it needed a knowledge how to justify. So a shift from these judges who did, or lawyers as well, who practiced knowledge of that and sort of led were leaders of fact into a knowledge of how, which are leaders of method. And therefore, this is what is known as the conscious lawmaking pound referred to. And as a locus of conscious lawmaking shifted to legislatures and administrative agencies, the common law ceased to be a kind of knowledge that, and increasingly a knowledge how. Legal thinkers surrendered specification of ends of legislatures and administrative agencies and began to see their job as a specification of ways, means, processes, and procedures, that versus how. Therefore, as law's ontology shifted to being a means, however, modernist confrontation with the limits of consciousness combined with older common law vocabularies such that judges and legal thinkers continued to resist the impulse to entirely account for the conscious decision-making. This is manifested in the judicial career, as we will see, of Felix Frankfurter and the academic career of constitutional theorist, his Frankfurter's law clerk, Alexander Bickel. So this chapter will be organized in first, moving to section 2 after the introduction. We'll trace the career of common law until the end of the 19th century. Section 3 will examine common law's transformation into means and explores persistence of older common law vocabularies. And section 4 will offer conclusions as to the career of common law after its transformation into means. So my apologies if I will go through this quick. There's a lot of material to go through, but feel free to watch this again or also follow up with the text itself, the Oxford Handbook of Legal History, edited by Marcus T. Dupper. But I hope this will give you a great overview, as it has done for me, in terms of the history, tracing the history of common law. So, starting with section 2, or section 2 after the introduction, the common law before the 20th century. Means and ends is the title the author gives it. So, drawing upon Renaissance philological techniques, the 16th century Western European legal thinkers began to realize that the corpus of Roman law they had once considered an unchanging whole was in fact a messy amalgam of original text and subsequent annotation that had arisen in chronological time. And this had explosive consequences, in that if law had chronological time, did this not apply that it could be made as well in chronological time? So, as discussed in previous chapters, if it has a start and an end point, then it's therefore subject to greater change. Europe's would-be absolutist monarchs were quick to seize this opportunity. If law could be made, who better than the monarchs themselves? So in response to the royal aggregation of control over lawmaking, the early 17th century English common law thinkers came up with an authoritative formulation of the common law that consisted of the following interrelated ideas. A. The conjoined notions of legal temporality and substance. B. Ideas about the division of roles between between the sovereign, legislature, and judge. And C. Claims associated with the freedoms of the people and England's ancient constitution. So first, this caused in this time, so there were many changes that went on here. First, I would say, to sum up in my perspective, but perhaps not to fully exhaustive, there was a sort of, the monarchs seized this opportunity to use the law to their power, but then there was sort of these divisions of power brought large part by the diminution of the powers of the monarch and the roles between the sovereign, legislature, and the judge, and then lastly between the claims associated with the freedoms of the people, which further strengthened the judiciary perhaps, but in a different way, but not necessarily through the king or the royals leading. So first, this moved away from the medieval ideas of law as timeless and universal. As mentioned earlier, in the early 17th English common law lawyers attributed a special non-historical temporality to common law that effectively inhumanized it from historicism. So that would be seen as the contemporary Roman law. This did not reflect the universal principles, but consisted of immemorial customs of English, which consisted of collective wisdom of multiple generations superior to other arrangements. No single individual, even a monarch, could exceed the accumulated wisdom reflected in the pronouncements of common law. of the common law judge. So this is before the temporality of the law. Then second, following upon this, common lawyers insisted that only the common law judge possessed the necessary qualifications to articulate what they called reason of the common law. Sir Edward Coke, the thinker more than any, according to the author, to restate the common law in the early modern period, extolled the common law as an artificial perfection of reason, gotten by long study, observation, and of experience, and not of every man's natural reason. So sort of made an exclusive lawyer class. The common law judge had right to declare limited monarchical encroachments and legislative tampering, as such seen in Bonham's case in 1610. Coke suggested that the common law might go so far as to limit the reach of parliamentary statutes when, quoting, that when an act of parliament is against the common right and reason, or repugnant, or impossible to be performed, the common law will control it, and a judge such act would be void. So there was at this time sort of a supremacy over the judiciary over the monarchs. Then third, the common law's strongest claim to legitimacy was that it embodied the immemorial customs of the English. Quo custom, it is called in Latin. The common law was deemed to arise spontaneously and to crystallize by dint of repetition over time, because the common law judge merely declared what was already there. Common law was freer and better suited to the people than the acts of kings and legislatures. In the modern Attorney General for Ireland, Sir John Davies, in 1612 Irish reports dedicated to Lord Chancellor Ellesmere, equated common law with the common custom of the realm. So at this time, in the 17th century, it had almost a supremacy over the monarchs. And according to Sir John Davies, this customary law was the most perfect and excellent, and without comparison the best, to make and preserve the commonwealth. For the written laws which are made either by the edicts of princes or by the councils of estates are imposed upon the subjects before any trial or probation made. But a custom doth never become a law to bind the people until it had been tried and approved time out of mind. So there's sort of once again, the supremacy of the law over even the monarchs. So thus, the 17th century brought these together, these three forces, ranging on different scales from England's ancient constitution to doctrines that govern relations between private individuals and between individuals and the state. Thinkers such as Coke insisted that common law of their day come down to them unaltered from the Anglo-Saxons' times, so kind of this doctrinalism as we've seen in Roman law. By the end of the 17th century, it became unsustainable, however, and the work of the antiquarians was beginning to prove that there was what had been considered immemorial, especially the laws of real property and political structure, was the result of the Norman conquest. In the late 17th century, common law thinkers had to confront the fact that common law was a legacy of feudalism. So this sort of power of the law and even supremacy of the monarch was subject to decay. And in response to this assertion that the common law had changed in chronological time, lawyers created an enduring language to characterize not the common law's substance, but rather its method. Nevertheless, they maintained that the change insensibly was slow, gradually, and incrementally, so the change was slow and incremental, and that its movement went unnoticed by those it touched and dissolved into continuity. Sir Matthew Hale, in his History of the Common Law of England, observed in his well-known passage, "But though those particular variations and accessions have happened in the laws, yet they being only partial and successive, we may with just reason say that they are the same English laws now that they were 600 years since in general. As Argonaut ship, the famous Argonaut ship from ancient Greece, was the same when it returned home as it was when it went through in a long voyage. It has successive amendments and scarce became back any of its former materials. By virtue of its common law, with joint identity and differences, both changing perpetually and never changing." So to sort of address this fact, if law is changing, does law ever exist? Coke writes here that he references Argonaut ship, that Sir Matthew Hale references here Sir Argonaut, the Argonaut ship. If a boat goes to sail and over time each part changes and it comes back with completely different parts, but each part changed successively, it's still the same ship, supposedly. And then following this, so law sort of does have this immoral aspect, although it's changing and imperceptible to the, if one were to look at it at one point in time. In the 18th century, following Parliament's victories over the monarch, common lawyers switched from worrying about law-giving powers of British lawyers to worrying about law-giving skills of Parliament. This incremental method, calibrated with the continuity and change, was better than the episodic legislative acts. According to Sir William Blackstone's mid-18th century commentaries on the law of England, which is unquestionably the most influential single text in the common law tradition, hailed by common law judges as living oracles Sir William Blackstone hailed common law lawyers as living oracles who were long personally accustomed to the judicial decisions of their predecessors. So although there was this period where the monarch tried to seize the power of the changing law, it comes back to the power of the lawyers once again with Blackstone as the sort of the one to lead the charge but also narrate the charge. And he pressed on parliamentarians a common law sensibility to watch, to check, and to avert every dangerous innovation, and to propose, to adopt, and to cherish any solid and well-distinguished improvement, and to be bound to transmit the Constitution and those laws to the posterity, amended if possible, at least without any derogation. So more power to the lawyers, but also sort of acknowledge that, but as well as acknowledge how. And the parliamentarian himself for the Tories, not the Whigs. So Blackstone became a parliamentarian himself for the Tories, which are sort of the more liberal one might say. History had ceased to be a mere matter of chronological dating and came to possess a powerful meaning of direction, known as the philosophy of history, and comes from this century. Also manifested by Scottish Enlightenment feudalism to commerce narrative, the withering away of feudal land tenures, and expansion of commerce and finance, and the growth of the empire as well led this. And his last quote from Blackstone: "We inherit an old Gothic castle, erected in the days of chivalry, but fitted up for a modern inhabitant." So this importance of the lawyers to take a hands-on effect, but also the parliamentarians as well. So there's also that sort of slight diffusion of the powers, of alluding to the slight diffusion of the powers of the judges through the separation of judicial and executive or legislative powers. The American Revolution, moving to the other side of the Atlantic, was inspired by many different intellectual currents. Republican thought, Lockean natural ideas, John Locke, Scottish historical concepts, Protestant millenarian notions, and common law ideas. Yet more radical voices saw the overthrow of British power as an opportunity to wipe the slate clean. In Common Sense, by 1776, published by Thomas Paine, one of my favorite pieces of writing, the author wrote, "We have it in our power to begin the world over again. The birthday of the new world is at hand," and he could not have been more at odds with the common law sensibilities, in that it was not shared by all Americans of the Revolutionary era. And on both sides of the Atlantic, critics found terrifying instantiations of the French Revolution, which began shortly after in 1789. So there was sort of some fear of Thomas Paine's thought of rewriting all the laws or rewriting the entire government structure, and essentially what came to be a constitution, and fear of what was to come in the French Revolution. In Edmund Burke's Reflections on the Revolution in France, published in 1790, he defended British constitutional order as a sort of immortality through all transmigrations, so advocating for this immortality of British law and advocating to not change it too much. And the British political system, he says, is never old or middle-aged or young, but in a condition of unchangeable constancy, and moves on through the varied tenor of perpetual decay, fall, renovation, and progression. In what we improve, we are never wholly new. In what we retain, we are never wholly obsolete. So, and he found support in the independent United States College in Philadelphia, which became University of Pennsylvania, where I studied at the master's level in 1790 to 1782, where the U.S. Supreme Court Justice James Wilson assured the audience that with regard to many subjects we have renewed in our governments the principle and the practice of the ancient Saxons. Most American legal thinkers at the time would have likely concluded it impossible to make sense of the written Constitution in isolation from the unwritten common law background. So, sort of, even though there was the American Revolution before, even the French Revolution, they still many leading jurists and advocation for even looking beyond the Constitution and such, but even drawing Old English or Saxon law specifically into the United States in this sort of timeless effect. Throughout the 19th century, but especially in the early Republic and Jacksonian era, common law vigorously attacked for its British monarchical feudal origins on the ground that it was the shadow cast by the past over the democratic majority of the present, and because it was administered by unelected judges, so once again coming under scrutiny. Despite some unsuccessful attempts at codification, however, common law not only survived in the United States, but enjoyed considerable prestige, so it never got fully codified, as you might see in civil law systems. If it was codified, it would be civil law. And therefore, American society understood the world to have given foundations from God, history, nature, or something else, perhaps the UK or somewhere in Europe, and the 19th century knowledges suggested limits to human thought and action beyond the power of human beings to change. This limits on self-making could be seen in Bradwell v. The State in 1872, where the U.S. Supreme Court was asked to rule on whether the recently ratified 14th Amendment would render invalid an Illinois law barring women from the practice of law. The court refused to extend the amendment in this way. According to Justice Bradley's concurring opinion, shows how the law of nature and the Creator could be used to squelch a woman's demand for self-making. The civil law, as well as nature herself, has always recognized a wide difference in the respective spheres and destinies of men and women. So even this historical effect overrode the 14th Amendment in this sense. And the paramount destiny and mission of women are to fulfill the noble and benign offices of wife and mother. This is quoting Justice Bradley. This is the law of the Creator. In the nature of things, it is not every citizen of every age, sex, and condition that is qualified for every calling and position. Similar beliefs applied to limitations on natural hierarchies of class and race as well. So it was almost used for maybe negative effects, as I think most today would agree, and many believe the firm limits to what political democracies could accomplish. Thomas Carlisle, in the mid-19th century, conservative writer, very popular in Great Britain and the US, wrote on heroes, hero worship, and the heroic in history, one of my favorite books as well. I think it's not to go on too much of a tangent, but something that should be seen in contrast to the philosophy of Tolstoy. Wrote in his later day pamphlet in 1901, the political democracy could not enable a ship to round Cape Horn. Your ship cannot double Cape Horn by its excellent plan of voting. Ships accordingly do not use the ballot box at all. Democracy is a very extraordinary method of navigating, whether in the Straits of Magellan or the undiscovered Sea of Time. So this is Thomas Carlyle sort of I guess putting that nail in the box so that, for example, a ship could not run on democracy because there would be perhaps too much disorder. So therefore, perhaps too much democracy might not be the best in the United States, and therefore, going back to Justice Bradley's decision that women should not be allowed to admit it to the bar, which has since changed, however. Therefore, in a world in which a myriad of foundational knowledges constrain self-making by individuals and democracies, the common law functioned as one constraint among many. For much of the 19th century, the American state was relatively undeveloped, with a burgeoning number of legal treaties and an active bar. American common law judges filled the regulatory vacuum created by the states by regulating contract, property, and tort law so as to enable the transformation of the U.S. agrarian economy into a commercial and industrial powerhouse. Far from a problem, the American democracy judge made common law lauded for its substance and gradualist method and ability to bind past, future, and present together. This was clear from any number of 19th century American treatments of common law. For example, James Walker's The Theory of Common Law, published in 1852, argued the common law presents for our investigation a continuity of doctrine which binds the present to the past, a chain of rules unbroken by revolutions, not blurred by codification, in short, a body of original facts. It is stable because its principles are founded upon truth. It is capable of amelioration because that is the nature of humanity. Therefore, it had a certain prestige and power, and it was better able to instantiate the logic of history than the legislature was. So at this time, perhaps the judiciary may have even been seen as more powerful than the legislature. So at least perhaps relatively more powerful than now. And as the 19th century drew to an end, the understanding of democracy, law, and history had created a particular place for the common law and American polity were beginning to unravel. It is to an account that this erosion, that the remaining place for common law, the American polity, that we will now turn. So I think just to tangent as well, the brief reference to Alexis de Tocqueville, he wrote that, not to paraphrase him too much, but that in America the lawyers are the closest thing to an aristocratic class, and at least during this time it seems to be more manifestly true than today, but maybe it is still true, who knows. But at least many lawyers are as well in the legislature, but one must still, they're not practicing lawyers at the time regardless, so perhaps less so than maybe de Tocqueville envisioned. Moving to section 3, and I'll try to maybe pick the pace up as well, but feel free to even slow down this video if you have the capacity, or speed up if you'd like to, as I often do. So the common law as means, the 20th century, section 3. So that was sort of the common law as substance, and now we're seeing the shift into common law as a means. So he says, the author says, the modernist historical sensibility was brought to bear in important ways on law in general and on the common law in particular. In the 19th century, writings of Oliver Wendell Holmes, Jr., the foremost American legal thinker of the period, revealed with breathtaking clarity how in his Little Red Now, The Common Law, published in 1881, was a model for the modernist historical method, and it opened with lines now celebrating, rendering how law, which claimed to embody formal logic and founded at the touch of history, in this quote, the life of law has not been logic, it has been experience. The felt necessities of time, the prevalent moral and political theories, institutions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do than the syllogism in determining the rules by which men should be governed. Therefore, logic, reason, and morality, nothing more than an agglomeration of historical errors, clumsy switches of substance, and procedure or long-forgotten transpositions from one context to another. Therefore, modernist history at its best is history used to tear down rather than to point to any particular direction. So that is this sort of modernist approach to sort of tear down, that it's a clumsy process and therefore needs greater scrutiny. Might also be as drawn parallel to critical legal studies as well, but quite different. but at least it's maybe similar in intention. So moving forward, to further elucidate this shift, in The Path of Law, published in 1897, and The Privilege, Malice, and Intent, published in 1894, he intensified the assault on antiquity and continuity, stating, "It is revolting," and this struck a chord in the 19th century and gave way to the 20th, that the U.S. was engulfed by a massive socio-economic transformations resulting from urbanization, industrialization, and immigration, and common law courts that had been made law for much of the 19th century were deemed unfit to handle these challenges because their solutions were individual-centered, fault-based, and private law doctrines, which included as well diverse groups such as farmers, labor unions, urban reformers, and others pressed for legislative and administrative solutions that were truly social in scale. So, although the common law courts could be directed to some extent, they were specific and focused on one individual at a time, for example, whereas these groups, which could be seen as almost lobbyists at the time, would advocated for legislative and administrative solutions. And this was manifested in the battles between the U.S. Supreme Court on the 5th and 14th Amendments in the Lochner v. New York case. In 1905, and the U.S. Supreme Court struck down the New York law regulating workers' and employers' liberty of contract and work hours. So therefore, just essentially the U.S. Supreme Court having power over a legislative body, so sort of a resistance to this force. And from the 19th century into the mid-1930s, the U.S. Supreme Court struck down state legislation in approximately 400 cases, and more than half of these were decided on the basis of the 14th Amendment. So although there was much pressure to shift the power to legislative or administrative bodies, there was still much resistance from the U.S. Supreme Court, and as well as probably likely true as well throughout the appellate court circuits. Critics of progressive era decisions, such as Lochner, sees the Holmesian critique in that the Supreme Court Judge Benjamin Cardoza defended the profession of unelected judges, because another criticism is that these judges were unelected as opposed to legislatures who have been elected democratically or more directly, and stating that there is no doubt the limits of judge are narrower, and nonetheless within the confine of these spaces and those of precedent and tradition, choices move with freedom which stamps his actions as creative. This distinction between law and politics had eroded by the 1920s, and the three non-mutually exclusive responses to this tension. So here there's a real clear divide that these judges cannot accomplish all of the objectives that perhaps the legislatures should fill. And these three non-mutually exclusive responses to this tension are first, especially in the realm of constitutional law, one response to the collapse of law-politics distinction brought about the rise in modernist thinking was to argue for ever more deferential standards of constitutional review. So these three things that the author here, Dr. Parker, elucidates here are, firstly, what are the results of this division of law and politics? First is that constitutional review becomes more brought to the forefront. Second, in the early 20th century, various schools of legal thought with names like sociological jurisprudence and legal formalism attempted to situate law in a social context to get away from excessive legal formalism and conceptualism. Viewed thus, law would simply vanish into society and law everywhere. So it's sort of also, while having a more siloed focus on constitutional law, it also has a sort of dispersion into society, and as we've seen in the law and society chapters. And third, and coming to the focus of this chapter, legal thinkers reimagined the role of law in relationship to political democracy in ways that were far more transformative. Just as modernists in various realms of endeavor were shifting from knowledge that to knowledge how, early 20th century legal thinkers insisted that legal knowledge cease to check democratic legislatures on substantive grounds and increasingly focus on the specification of ways, means, methods, processes, procedures, and protocols for arriving at substantive decisions. And this new distinction between law and politics, and realist Carl Llewellyn put it in 1931, "For while we may properly proclaim that general propositions do not decide concrete cases, we nonetheless must recognize that the ways of deciding, ways of thinking, ways of sizing of facts are distinctly enough marked for our courts so that we can know a lawman, by his judging reactions from a layman." So here, the important Carl Llewellyn, an important legal scholar, notes that the difference between a lawyer and a layman is that the lawyer knows the ways of doing it, not necessarily the substance. So therefore, perhaps a layman can read up all the laws, but the lawyers perhaps know the procedures. Hence why maybe legal procedure is one of the most important courses in law schools. So moving forward, so substantive law could be packaged as a means. Going back to Pound in 1921, he pointed out it differed sharply from its rival Roman law, which would be focused on substance, and that the central idea in developed Roman system is to secure and effectuate the will. All things are deduced from or referred to the will of the actor. However, the common law tradition focused not on the will of the individual actor, but rather on the feudal legal relation: master-servant, landlord-tenant, bailor-bailee, principal-agent. Therefore, there was more leeway for shaping rights, duties, warranties, and the like. But Pound was interested not in the context of any particular set of relation, but in the technique. Pound also feared the rise of executive justice, the tendency to commit everything to boards and commissions, which proceed extrajudicially and expected to be a law unto themselves. So although there's maybe a lot of benefit in having legislatures have much control over the directions of society, having too many boards, or especially unelected boards that are laws upon themselves, is evidently a cause of worry. But the author notes that maybe he need not have worried, as enterprising lawyers like the progressives like Felix Frankfurter, who will be discussed shortly, and later New Dealers recognized the infiltration of common law procedures in the administrative state was an opportunity, and the lawyer is in many ways the coordinator, the mediator between various social sciences. So maybe Pound was overly worried because, as Kunal M. Parker notes, as Felix Frankfurter and the New Dealers showed, there's still a large necessity for lawyers to involve themselves in these decision making. So a high point of the pre-Second World War emphasis on law as a means was the coeval triumph of the New Deal and the U.S. Supreme Court's retreat from the Lochner in the United States v. Carlisle products, particularly in footnote 4 in the case in 1938, in that Justice Stone suggested that it had now given up on substantive due process of the Lochner variety, and the court might be subject to a more exacting judicial scrutiny under the 14th Amendment, and therefore intervene in the affairs of democracy only upon failure of the democratic process. So very, very important case, particularly in American law, but probably all common law as well, in that the court should intervene in affairs of democracy only upon failure of the democratic process. And that's from footnote 4 of the Carlisle United States versus Carlisle Products case of 1938. And that's a complete shift from the Lochner case, where they were intervening with legislature's decisions. And therefore a means and process was a response to threats as well of Nazism and Stalinism in searching for defensible legal limits of state power. So, as we've seen, particularly in, for example, the Gulag Archipelago, the judiciary is almost unseparated from the legislature. So, and as we also see in The Spirit of Laws by Montesquieu. So, and this was also strengthened through the rise of Nazism and Stalinism, and therefore the resulting effects in the United States. Then there's still no clear separation between law and politics, as illustrated by the judicial career of Felix Frankfurter after his elevation to the U.S. Supreme Court in 1939. He notes, "I'm bred in the law, I'm a common lawyer," and therefore notes the expertise of the lawyer, and the only expert field of lawyers could resolve issues of the threshold of constitutional limitation and the jurisdiction of federal codes. So Felix Frankfurter is under the impression, though, although there is a limit, it's up to the judges or the lawyers to decide where the limits of the courts are, and the feeling of the courts, and the work of the legislatures between the constitutional law and the episodic legislation politics. So this is the clash that Felix Frankfurter puts forward, is that the work of the legislatures is manifested by the Constitution, and the episodic legislation is manifested by the politics. And the changing but slow and the most fundamental principle of the constitutional adjudication is not to face constitutional questions, but to avoid them if at all possible. So although that is their main area of expertise would be the constitutional areas, is to try to avoid them and sort of only intervene when necessary. Mr. Justice Holmes was led by the divination of the philosopher and the imagination of the poet, and that the divine abilities are the highest praise in the dilemmas of the due process clause. So the due process clause became of greater importance as the judiciary became a more functional, or in noting more focused on the means. And therefore the legal process school rise in the post-Second War period, led by Alexander Bickel, who was a clerk of Felix Frankfurter, Paul Freyond, Louis Jaffe, Edward H. Levi, Henry Hart, Albert Sachs, Herbert Werschler, Harry Wellington, affiliated in one way or another with Frankfurter. In the late 1950s at Harvard Law School, which is noted by the author as the capital of legal process thinking, a student reminiscent, Felix Frankfurter was a god, and the emphasis on procedure, noting his emphasis on procedure, and Hart and Sachs wrote procedures are the most significant and enduring part of the whole legal system because they are the matrix of everything else. Frankfurter's emphasis on procedure found by far its most conservative and common lawyerly rendering in the writings of his law clerk and protege, as mentioned, the legal process scholar Alexander Bickel, who wrote, "The sound judicial instinct will generally favor deflecting the problem in one or more initial cases, and there is much more to be gained from letting it simmer, so that a mounting number of incidents exemplified may have a cumulative effect on the judicial mind as well as on the public and professional opinion." So that's sort of interesting. One way of addressing the having not too much intervention from the judiciary is waiting until there are more cases accumulate, firstly to get a larger sample size, but also to not unduly get involved. And the tension between the expediency and principle is manifested here, and therefore the legal process school extended its influence well into the 1970s and beyond, and John Hart Eli's Democracy and Distrust, published in 1980, being the grand synthesis of U.S. constitutional law as filling out the process and using the logic of the Caroline Products case, footnote 4. So it's sort of that fully elucidated by John Hart Eli. So here we are now since the 1980s and moving as well to the conclusion. So he notes the author here, Kunal M. Parker, Dr. Kunal M. Parker, notes the emergence of modernism and erosion of foundations that it entailed was key to the transformation of common law in the 19th century, gave way to the 20th, and that modernists switched from knowledge that to knowledge why, and common law increasingly surrendered its claim to check democracy in substantive ways and became instead a means, ways, process, and procedures. And therefore this could be seen as perhaps more conservative as well. De Tocqueville also notes that the lawyers are one of the most conservative elements as well in America, and perhaps even more so after this shift. And as the author notes, it is not clear this procedural rule was able to become a fully conscious kind of lawmaking, as evidenced by Felix Frankfurter and Alexander Bickle's importance of expertise and skill. So although it might be more conscious of its purpose, it's still perhaps room for much significant error. And he also, the author here, notes there are still other factors such as the more comprehensive of how common law in the 20th century America intersected with libertarianism, law and economics, and Christian conservatism. And that he notes that story is not told here, but what has been told here could connect up with what has not been insofar as it underscores the protean character of common law, which is a perplexing marriage of skepticism and mystification, modern historical sensibilities, and pre-modern temporalities through which the common law made a career in the 20th century America, and gesture to the way it functioned in other fields, disciplines, and ways of knowing. I think a good follow-up on this would be also to look at the Marcus Dubber's chapter as well in the Oxford Handbook of Legal History on elucidating the direction that common law might be going, which might be a direction towards more doctrinalism, and as we will see perhaps in the civil law chapter, that civil law might be becoming more interdisciplinary. But nonetheless, that is the chapter by Kunal M. Parker, which I think is a great trace of the common law legal history throughout the most recent 300 years, I would say, or even 400 years. So absolutely fascinating and very important. So I hope you enjoyed that. We will go discuss the slide content here, and then we will talk a little bit more about the author and perhaps his content as well in the comparison. So his chapter is in part 4, Traditions Tracing Legal History. It is chapter 37 of the Oxford Handbook of Legal History, The Transformations of the Common Law, Modernism, History, and the Turn to Process by Kunal M. Parker. His institution is the University of Miami. His positions include Professor of Law and Dean's Distinguished Scholar. His research interests include American legal history, estates and trusts, immigration and nationality, law, and property. The images we have here are in the top bottom right. We have Dartmouth College, where he spent 3 years. In the top right, we have Harvard University, where he received his Bachelor of Arts, and as well his Juris Doctor. And in the top left, we have the seal, the Great Seal of the University of Miami, where he is currently a professor and Dean's Distinguished Scholar. His suggested readings include his first book, Common Law, History and Democracy in America, 1790 to 1900, Legal Thought Before Modernism, published by the Cambridge University Press in 2011, and his second and most recent book, Making Foreigners, Immigration and Citizenship Law in America, also published by the Cambridge University Press, however, in 2015. And the 3 quotes I have here. First, Pound hints at a historic shift from unconscious to conscious lawmaking. He also strikes a note of caution. It is possible to have too much faith in the latter. Next quote, as the locus of conscious lawmaking shifted to the legislatures and administrative agencies, the common law ceased to be a kind of knowledge that and increasingly became a knowledge how. And third and last quote, the perplexing marriage of skepticism and mystification, modernist historical sensibilities, and pre-modern temporalities through which the common law made a career in the 20th century America gestures to the way it functioned in other fields, other disciplines, and other ways of knowing. So very, very important chapter on common law by tracing legal history of common law by Kunal and Parker. Next, we will move to the chapter by Heikki Pihlajamäki. Pardon me for that. It's a Finnish name. I have many Finnish friends, so they've helped me pronounce the name. I'm hoping I'm doing such, and they've also, I referenced them particularly. For example, Danya Haga helped me in understanding the court system in Finland before going through with this chapter, specifically in this biography. So, this chapter is titled, it is in section 4 of also the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins. In section 4, Traditions Tracing Legal History, it is chapter 8, Tracing Legal History in Continental Civil Law. And as with the previous chapter on common law, this is probably the most representative history of civil law in the textbooks. Other sections touch on civil law, but this one is the one most focused on civil law, and conveniently it is paired with our common law one as well. So, to start with a brief biography of the style of Plutarch's Lives on Heikki Pihlajamäki. He is the Academy Professor at the Faculty of Law at the University of Helsinki in Finland, and he has been in this position since 2021. He's researching the comparative accounts of early modern colonial law of England, the Netherlands, where I currently am based in The Hague, Spain, and Portugal, and how they evolved. And he is setting colonial laws in two contexts. First, the historical continuation that links colonial experience to the Middle Ages and the early modern context of continental European empires, including Sweden, Germany, and Russia, as well as setting legal orders of early modern powers traditionally defined as colonial powers in close context with other European empires expanding at the same time, where he is systematically comparing early modern overseas legal orders with each other, and therefore also culturally contextualizing and using comparative methods best characterize his approach. So very, very fascinating legal scholarship, and I think makes him very, very key authority on civil law. So he received his Master of Law from the University of Helsinki in 1987, and his licentiate in laws at the University of Helsinki in 1991, and his Doctor of Laws from the University of Helsinki in 1996. He served as a clerk for the lower court of Lappi in Lappeenranta, which is a district court, so just below the appellate courts, and then there's also the Supreme Court as well. He also served as a lawyer in the National Board of Construction and a legal officer for the Office of the Parliamentary Ombudsman. He was also a visiting scholar at the University of Belgrano in Buenos Aires, Argentina, as well a research and senior academy fellow at the Academy of Finland, and a lecturer in legal history in 1997 at the University of Helsinki. So he spent a significant time there, and although more recently became a professor, he was a lecturer there for quite a significant amount of time as well. He was also a visiting professor of law at the University of Tartu in Estonia in 2002. He was selected Teacher of the Year by the Law Students Association in Pihlajamäki in 1999 and in 2002, or nominated twice. And he was the nominee of Aino Kaila Prize for the Teacher of the Year at the University of Helsinki. He won the Teacher of the Year by the Law Students Association Pihlajamäki in 1999 and 2002. And he was the nominee for the Aiko Kaila Prize for the Teacher of the Year at the University of Helsinki in twice as well, including 2002. He was the Erwin C. Surency Prize, won the Erwin C. Surency Prize of American Society for Legal History for his article titled The Painful Question, The Fate of Judicial Torture in Sweden, in the Law and History Review in 2007. He has 18 books, and most recently the Oxford Handbook of European Legal History, where he is an editor alongside Marcus D. Dubber, who is an editor of the Oxford Handbook of Legal History, and M. Jeffrey as well was another editor, published by, as you may guess, the Oxford University Press in 2018. He also wrote Understanding the Sources of Early Modern and Modern Commercial Law, Courts, Statutes, Contracts, and Legal Scholarship. Here is an editor alongside H.T. Cordes, A. Dauchi, S. de Reuscher. Published by the Brill Nijhoff in Leiden, which is just a little bit north of me in the Netherlands, in 2018. And as well, The Conquest of Law in Swedish Livonia, circa 1630 to 1710. A Case of Legal Pluralism in Early Modern Europe, published by Brill Nijhoff, also in Leiden in 2017. So his title is in Section 4 of the Oxford Handbook of Legal History, Traditions Tracing Legal History, Chapter 38, Tracing Legal History in Continental Civil Law. So starting with the introduction, he notes, the German sociologist Hartmut Rosa discusses a detemporalization of history in late modernity. What has been lost are the metatemporal plans of history, life, and daily activities that determined the temporal qualities of events and actions beforehand and made the time of history susceptible to planning and allowed them to appear directed. According to Social Acceleration, a new theory of modernity, published in 2013. He notes it's not by accident that history as a scientific discipline was born in the 19th century to provide such a metatemporal stories. This lost world of history also was the period of classical Weber concept of modernity in the 19th and 20th centuries, carrying with it the Enlightenment belief in social progress. And in the 1960s and 1970s, this all changed, however, and the social theoreticians of historians rarely believe in progress or any similar ground stories anymore. So that's quite a lot of content in there, but essentially modernity, the modernists, and also science have had large effects on the influence of history in civil law. However, in the 1960s and 1970s, the social theoreticians and historians have come back or had a larger influence, but however they shifted away from grand narratives. But this will all be more clear as we continue through the chapter. He notes history of continental legal history reflects these changes, in that legal history was a product of the 19th century modernity. Examples of historical research in law from pre-modern era, which is pre-19th century, so when we refer to pre-modern, that's pre-19th century, show that although methodologically pre-modern legal historians were no less able scholars, their scholarly interests were different. They were concerned with certain elements of the past only, such as legal sources of ancient Rome, etc., and that they could help create a glorious past for their country. So they sort of had not a propaganda-like notion, but they had a certain purpose of using history. So history as a means rather than history as an end. In the 19th century, this changes, however, and legal history became, in the first stage, the instrument which helped to distinguish the best parts of legal heritage in order for them to be developed further and to serve as building blocks for a new systematic legal order, and a second positivist phase when the legal system started to be developed without being detached from history. And legal history was therefore left on its own, sort of, it got its own silo, but being autonomous. It now evolved into a device which served as legitimization for existing legal orders. So autonomous, but sort of validate existing laws and legal orders. In late modernity, which is the 1970s and following, legal history increasingly became a device of critical theory and as an independent discipline, and therefore a greater separation, but also led by perhaps the critical legal studies. Commonplace claims such as current law cannot be understood apart from its history have been far from self-evident when one observes civil law in a long perspective. Some exceptions notwithstanding, legal history has played a minor role in law and legal scholarship on the civil law side, particularly, or not particularly, but in as our subject right now. By looking at legal history written by legal scholars, this chapter will reveal the value of legal history increased when reasoning depended on historical arguments. So there was a value of historical arguments, and when legal reasoning had been less interested in historical points of view, the significance of legal history decreased, and nevertheless, to some extent, history has always been present in the continental civil law, as we will show. Besides legal reasoning, fluctuations from changes in historical scholarship have greatly influenced legal history. So perhaps, as put forward by Pihlajamäki, the legal history has always been present, but perhaps its purpose has changed, or likely, or as he will show, its purpose and means have changed. This chapter proceeds chronologically. Section 2, after the introduction, starts with the introductory note on the role of legal history in ancient Roman law and the legal scholarship of medieval glossators and commentators. However, this section mainly discusses the first legal historians. the 16th century humanists. Section 3 then turns to dominant schools of continental legal scholarship in the 17th and 18th century, known as the Neo-Bartolists and the Usus Modernus Pendectorum. And although these schools gave considerable prestige, considerably to a pressing need to accommodate modern legislation with the inherited jus commune, which is common law, but law common, not common law, as we referred to in the previous chapter. Legal history still contributed to a great extent to their work, and Section 4 will concentrate on the rise of the historical school in Germany and the corresponding movements from elsewhere in Europe. Methodologically, the representatives of the school were the first professional legal historians in the modern sense of the term, yet their method was intimately linked with the emerging science of law, Rechtswissenschaft, which is German for science of law, and was not an independent discipline as legal history is today. And Section 5 explains independence of legal history as paradoxical consequence of marginalization within legal scholarship. And towards the end of the 19th century, it will be shown that law increasingly turned to a positive branch of scholarship, and in-law positivism meant the dominance of statutory law that left little space for legal history in argumentation. Therefore, legal history turned more than anything into a national discipline and a backup science for the natural scholarship of positive law. And Section 6 retells the story of the rise of the European legal history in the post-war period and the recent trends towards a creation of global legal histories. It will be shown that legal histories have in many ways not only followed in legal scholarship in general, but also the developments in historical science and global politics. In our rapidly changing legal universe, this may be legal history's best chance to survive and its only hope. So, a lot will be covered in this chapter. There will be 5 sections to follow, so bear with me. I'll try to go through them quite quick, but nonetheless, you will hopefully get a feel of the changes over time, starting with the humanists all the way up to the modernity. So, without further ado, we will start with Section 2, or titled Legal Humanism and Legal History. So, the legal humanists of the 16th century were the first legal scholars specifically interested in the history of law. Ancient Roman jurists, he notes, were too practical-minded to care for legal history, and medieval glossators and commentators, although relied on historical sources, such as Justinian's Corpus Juris Civilis, were notoriously disinterested in the historical veracity of their interpretations. So, little note here, please, I hope you watch my previous video on Roman law and canon law to learn a little bit more about these two. And as you will see, there was history in both of these, but perhaps according to Heikki Pihlajamäki, doctor, the real first scholars specifically interested in the history of law were the legal humanists in the 16th century. Glossators interpreted corpus as a self-consistent body of rules. The practical functioning of the text mattered as well, and therefore they glossed over it, but there was no space or need for historical ponderings. Late medieval humanists specialized in letters were already criticizing medieval jurists for their lack of interest in history, and representatives of jurisprudential elegantior, later called legal humanism, frowned even more upon them. So there was, even during these times, though, although there was not significant specific legal history, even in medieval times, there was criticism that there was not enough specific focus, and sort of alluded to the legal humanists who came in the 16th century. The history of legal humanism begins with Lorenzo Valla and Maffeo Veggio, whose main target of criticism was the corrupt Latin and medieval commentators. Valla's Elegantiae Linguae Latinae praised ancient Roman jurists whose texts had been included in the digest, and condemned Tribonian and medieval jurists such as Accursius, Bartolus, and others for mistreating the original Latin of the digest. So they sort of, this Vallas and this Valla and Veggio sort of went back and looked at these Roman works and noted that those who had observed the Roman works noted that they were using or taking a non-historical approach and sort of tailoring their history for specific purposes. Veggio's De Verborum Significatione pointed out that if Tribonian had not already mutilated the original text, Bartolus would have had no need for his baffling commentaries. So nonetheless, they were many mutilations and many false commentaries, perhaps even on these Roman texts. Guillaume Bode and Ulrich Zasius and Andreas Alciato, usually considered as the first to have systematically practiced the humanist method of legal sources, in that Bude's Annotationes in Pandectus, published in 1508, was a commentary on books 1 to 24 of the digest, and was more of an explanation of the defective texts and difficult terms, concentrating on the linguistic differences, and he had little interest in the cultural circumstances and legal dogmatic implications of findings. So maybe it was not the best to ignore the cultural circumstances, but the legal dogmatic implications of findings were not a focus of his, which makes it more historic, and focusing on linguistic context is a historical approach. Andreas Alciato wrote 3 important works using the new humanist methodology and moved the center of legal humanism in the 16th century to France, first to Avignon, then to Bourges, and his greatest followers in Alciate in Bourges were Jacques Cujas, François Hopman, François Duran, and Hugues Donneau. So he built a large following of these modernists who used this, at least more specifically, historical approach to many important previous works, specifically in Roman texts, but also in earlier medieval, and also late medieval as well. Although the author, Pihlajamäki, notes, although significance of legal humanism in development of legal scholarship was beyond a doubt, in practical legal life their importance always remained minimal. Peter Stein, the scholar, noted, the scholar could be a humanist, but the practitioner had to be a Bartolist. So although the scholar could focus on this specifically humanist or specifically historical approach, the practitioner had to be a Bartolist. Humanist legal thought also closely intertwined with the Renaissance admiration of all things antique and at the same time deep suspicion of medieval thought. Douglas Osler stated, legal humanism signifies the investigation of Roman law using philological and historical methods as part of the historical study of antiquity, and may be contrasted with a pragmatic, unhistorical application of Roman law to the conditions of contemporary Europe. It is equally important for humanists to identify incorrect interpolations made by Justinian's main editor, Tribonian, and his crew. So there's a certain purpose of the humanists to correct some of the wrongdoings or some of the falsities of the past. The author notes, the first wave of legal humanists were true legal historians, in that they were primarily interested in finding out the true wording of the ancient authoritative texts and in cleansing out false interpretations. At the same time, the traditional and conservative that they used the new philological and historical methods precisely to uphold the sanctity of the digest. So they still had a respect or appreciation for that which they were studying and did not want to completely destroy it. And the second wave no longer admired Roman law, however, as Donald Kelly noted, and many did not stop short of establishing interpolations of scholastics and Justinian's law drafters. So the second wave of modernists or humanists, pardon me, were much more critical of the Roman texts and Justinian. Humanists like Baudouin concluded it was also indispensable to chart the tradition of law before and after Justinian, and also wanted to understand the law in the first 2 centuries, now identified as the classical period of Roman law. So some of the humanists also noted it's not just what we have of Roman law, which was produced in the late Roman Empire, but also the earlier Roman Empire, and also the gap between Roman law and canon law. Some applied the new method even to the reconstruction of the 12 tables, and instead of wanting to save, some later humanists emphasized its poor suitability to their own world and used historical insights to argue the political points in their own time. So many also have this purpose of not wanting to apply Roman law, as we might see later in the divide in Germany between the Pandectists and the Germanists. Many of the Protestants and later humanists considered all Roman influences as vile and worth purging, and a move away from the Catholic Church. When the Reformation began in 1517, when Martin Luther published the 95 Theses, Francis Hauptmann attempted to show its main work, Franco-Gallia, published in 1573, that besides being a corrupt combination of classical and Justinian ingredients, Roman law had pushed out of its way Frankish constitutions and customary law that would have suited French more naturally. So this Franco-Gallia, published by Francois Hauptmann, says that not only was Roman law false, it also pushed aside previous French customary law that would have been more suitable to the modern France at the time. And as well, there was this notion that Roman law was contrary to the Catholic Church, particularly at the time when the Catholic Church was at its peak, likely right before the Reformation in 1517. According to a French lawyer equipped with Roman rules of property and succession, and disregarding the feudal law of land holdings, would be equally as lost if he had arrived among American savages, accordingly. Although the humanists had disdained canon and feudal law, the wish to establish longer perspectives of the tradition of Roman law led them to cast a critical eye on the history of the bodies of law as well. As with classical Roman law, they worked with philological methods, producing critical editions of central texts, most important including Gratian's Decretum. Lorenzo Valla, who had discovered the falsity of the donation of Constantine, was the first to attack this work, noting that neither Valla nor Erasmus, also aware of the historical deficiencies of Decretum, ever came to produce a critical version of the authoritative work on canon law. So although Valla and Erasmus, and as well, and maybe even Gratian, while they were, or maybe less so Gratian, but specifically Valla and Erasmus, while they were critical according to although they were critical of Roman law, perhaps they were not critical enough of canon law. This was done instead by Antoine de Mouchy in 1547 and the official contract correctors of the Roman Church in 1582. Humanists also engaged from early on in historical debates on whether feudalism was of Roman imperial pedigree, and some reinforced widespread contemporary assumption that derived from the ancient Rome, whereas others argued that had a modern origin. So whether feudalism came from Roman origin or modern origin was up to debate, but also necessitated historical study. This led to a decisive blow to the assumption from Charles Dumoulin in his commentary on the Parisian Coutume in 1533, and he asserted that the vocabulary of feudal law was modern and that much of Europe, France included, were politically not successors of the Roman Empire. In Libi Feodorum was the standard 12th century collection of imperial statutes and customs of northern Italy, was shown not to represent French or German customs, and Jacques Cujas, in his critical edition of Libri Feodorum in 1566, then confirmed all this. So this divide between Roman law and respective geographies, as had also been elucidated in previous chapters, particularly in the German and English context, necessitated a historical study and was led by these humanists. And although not directly useful in practical legal argumentation, legal humanism undermined the authoritative corpus juris civilis and its most influential part, the digest. After the 16th century legal humanists nailed down the theses, the law of Justinian increasingly looked upon as a historical artifact only and subject of rational critique. For proponents of developed absolutism, this was beneficial, as a space was created for rising royal law, as we referenced previously in the common law chapter, but for different reasons, and no wonder that Francois Altman, the legal humanist, decisively contributed to replacing the digest order of presenting legal materials with a new ordering principle inspired by the French humanist philosopher Pierre de la Ramée, or Petrus Rameau. The legal history once invented immediately showed its revolutionary potential. So much significant power was given to legal history this time. Moving to the next section, titled Legal History in Mos Italicus and Usus Modernus Pendectorum. So, author Pihlajamäki notes that Pihlajamäki notes that, pardon me, I will get this perfect, and I think I'm quite close, and if not, maybe already perfect, but I just have to keep practicing it. My apologies, Professor. So, moving to Section 3, Legal History in Mos Italicus and Usus Modernus Pendectorum, the author notes, despite French legal humanism having little impact on legal practice and waned as a distinguishable school in the scholarship after the 16th century, historical interests remained an integral part of legal scholarship. And this is the reason that today historians are careful not distinguishing too neatly between the legal humanists of the 16th and between humanism or Mos Gallicus, French custom, on the one hand, and Mos Italicus, or Italian, or Usus Modernus Pendectorum, or modern uses of the people. So these two opposing forces, whether in the Italian context or the French context, between Italian or French custom and the historical customs as well on the other. Though Mos Gallicus, which is the French custom, in the purest form as it was seen as a textual criticism, did not survive, the results of humanist learning could not be ignored. And the legal history in the text of the 16th century humanists proved not only a politically innocent method in service of antiquarian interests, but at times could also be true social and legal dynamite. So this sort of clash also between Mos Gallicus, which is French custom on the one hand, and Mos Italicus, which is the modern uses of the people. So not only a clash between Roman law, but a clash between this sort of French custom and the Italian method of modernity, but meaning Italian method contrasting Roman law. So therefore, if the birth of French and indeed continental legal history in the humanist form can be dated to the 6th century legal humanism, other European regions followed suit in the 17th and 18th centuries. Humanist research already coalesced with practical concerns. In Spain, for example, Mos Gallicus, the French custom, usually associated with Francisco Ramos del Mazzano, who lived from 1604 to 1683, and a professor at Salamanca, and had many followers, although he adopted the historical methods of the French humanists, at the same time continued everyday legal reasoning in the spirit of Mos Italicus, or Neo-Bartholism. So the Neo-Bartholism is perhaps the older method, which until then had been the dominating school of legal thinking. So the French method was sort of an evolution upon this Mos Italicus, this Italian method, or this Bartholianism method, which is the modern uses of the people. Well, that's technically what it translates. So in the German, Hermann Conring, who lived from 1606 to 1681, who's titled the father of German legal history, showed in De Origine Juris Germanici in 1643 how Roman law had not been introduced in Germany, contrary to what was believed in the Constitution of Lothair III, who reigned from 1134 to 1137, and instead there had already existed in works of 15th century scholars. The Dutch elegant school, or Dutch legal humanism of the 17th and 18th century, also was a prime example of early modern scholars combining humanist way of Roman law without its medieval binding autoritas with practical insights and local sources, as does Italian scholars active in England, Alberico Gentili. So essentially across all these different civil law geographies, and even perhaps one of the scholars in England, there seems to be a divide between, once again, Roman law and also modern custom. While Roman law and historical concerns did not disappear within legal humanism, notional legal scholarship gained around the 17th and 18th centuries. Incidentally, many fathers of national legal historians were also 17th century scholars that followed Ius Modernus with historical taints. So a lot of these people sort of switched over, but even though they switched away from the Romanist or the methods, they still maintained their historical approaches into the sort of modern context or their geographical contexts. Besides Ramos del Manzano, Conring, and John Sheldon, who lived from 1584 to 1654, who's known as the father of English legal history, Johann Stierenhoek, who lived from 1596 to 1675, known as the father of Swedish legal history, lived and worked in the same century. De jure masterpiece belonging to an antiquarian nationalistic history writing must be taken in context of the contemporaries Grotius and Conry, both with ties in Sweden. So there's also this shift in Sweden as well. So almost across, one might deduct across all civil law countries to different extents, with Sweden also being a leader here. All point towards Conring's De Origine, with the refutation of Lotharian's legend, and this Lotharian legend, but the Constitution of Lothair III, who reigned from 1134 to 1137, tried to connect Roman law with Germany, perhaps for prestige and for many other reasons, or perhaps divine right and such. But they were all led to the break from Roman law. While Stierenhoek could focus on jus commune, which translates to common law, but it's like the law common, not common law as we understand it, in contrast to civil law, Conring had to explain why in the 17th century Germany Roman law clearly was present in the scholarship and judicial process, and therefore to oppose Pandectists. Stierenhoek also embraced other histories, including Roman, and Olaus Rudbeck, 1630 to 1702, constructed a primeval Gothic Sweden, which he identified with Plato's Atlantis, and appreciated history as legitimate precisely because legitimate, including medieval canonists. So essentially, even in Sweden, they had this sort of Gothic Sweden, which was somewhat similar to Plato's Atlantis, but there was also many other scholars who had to sort of build up alternative histories to contrast the significance or prestige of Roman law, and there are some detractors as well, as noted. Therefore, legal humanism not only directed attention to true contents of classical Roman law, some also took to explaining the tradition of Roman law through the centuries of their own time. So some also, as we noted, like Conring, tracked its influence throughout countries, and some also wished to break it, tracked it to break it. Some increasingly understood it as a historical phenomenon that changed in space and time, while combining Roman law and local sources of law usus modernus pandectarum as practical jurisprudence continued the work of most practical-minded legal humanists. Pandectarum of the people, it was not to be confused with the Pandectists,
who are the German experts of Roman law codified by the Pandects. So we have this Pandectarum, which is of the people, which is that which it means, but we also have this Pandectists, who are those who specifically try to separate German law from, or who specifically brought Roman law to Germany. So they're almost polar opposites. So sorry if the words are similar, but I did not choose them. Moving to section 4, 19th century, the historical school. So the author, Dr. Pihlajamäki notes that legal history's next Blütezeit, blossoming time, began as a result of the 19th century cultural romanticism. Blütezeit means blossoming time in Germany. So this next shift in the 19th century was a result of cultural romanticism. Prussian aristocrat and professor at the University of Berlin, Friedrich Karl von Savigny, who's one of the most influential legal figures ever, emerged as the main progenitor of the new school of jurisprudence, and the author notes, can hardly understand Savigny historisch school without its surrounding cultural and political climate, noting that after the final demise of the Holy Roman Empire in 1804, Germany no longer formed a political entity, and after the French Revolution from 1789 to 1799, it had exerted a great influence on the German intellectual circles, causing many to turn conservative. Culturally, it was a period of romanticism and nationalism at the same time. From a legal point of view, many experts thought something ought to be done about the large numbers of legal sources inherited from previous centuries. So there's too many sources coming in, French, Roman, past German, and a corpus was becoming difficult for jurists to handle. Whether solutions was codification in French or Austrian style became a hotly debate. Savigny's famous program appeared in his pamphlet Vom Beruf unserer Zeit für Gesetzgebung und Rechtswissenschaft in 1814, where he compared law with poetry and language. All of them were developed freely, according to this analogy, in the consciousness of the Volk, the people, specifically the German people, and the legal historical investigations needed to discover how law developed into present and which parts and institutions were most endurable and worth preserving. And the answer was supposedly quite paradoxical, that Roman law, as it had developed through the centuries, which represented the best part of the German legal heritage. So because Roman law had lasted, it was the most enduring part, but therefore perhaps the most German as well. Jurists knew best how to interpret the Volksgeist, and law developed organically, and codification in the present state was not a good idea, according to this Savigny. So keep it uncodified at this time, and the strength of legal history lay in its power as tradition, and it was good because what was good was such because it had endured, which is something I use as an argument for history. People say, why read history? It's like, oh, maybe history repeats itself, perhaps, and likely such, but I also think a lot of it is good because it has endured. It has a sort of Darwinian effect. The non-good books, the older the book, probably the more historical forces to destroy it have gone through, and such they're essentially more likely to be good than a random new book written. If maybe a new book might be better than any of the classics, but it has not withstood the test of time yet, so we don't know. But that would be at least Savigny's argument for Roman law. Not an approach, and therefore it's not an approach itself, but it was linked to the view on jurisprudence, and it continued in the vein of more practical-minded humanists and the Usus Modernus scholars, and the system of Savigny's Rechtswissenschaft, or legal science, as mentioned previously, was elaborated by the so-called Pandectists. So these Pandectists are bringing Roman law into Germany, and Savigny is leading the charge, of which George Frederick von Puchte and Bernard Windschied are best known, and functionally replaced the lack of codification by providing Germany with a common framework of private law. There's at the end of On the Old Regime and the French Revolution, Alexis de Tocqueville notes that at the time, Germany, because they had such a strong Roman law, they had mastered the civil law but had neglected the private law, or neglected the public law. So they had mastered the private law, and therefore he said it was a slave law even. Eventually, the Pandectist legal scholarship provided the basis for the German Civil Code in 1900. So it's also noted previously by a previous author that in this textbook that because the German Civil Code was codified so much later, it was more dogmatic than the French Civil Code, and that is actually the chapter by Dubber, the editor of the textbook. And also, therefore, once again, going back to Tocqueville's, Germans had mastered the private law because their civil law code was longer. But it has recently been amended, so perhaps it is no longer such a slave-like, and evidently it is one of the most free countries in the world now. Savigny and followers dominated the first half of the 19th century, particularly from 1810 to 1849, and roughly a third of the teaching in law faculty of the University of Berlin was devoted to legal history. So, at least although one might not agree with the Pandectists, at least it was a good thing for legal history, at least in the civil law context here. And the link between legal history and the positive law remained close until the end of the 19th century and the promulgation of the code in 1900. The discipline was still not institutionalized as an independent discipline in law faculties until the years 1870 to 1930, paradoxically because legal history lost its immediate significance for contemporary law. So although it was not specifically an independent discipline, it was still very present, supposedly in a third of the courses. Legal history as a modern academic subject grew from the basis of the Germanist branch of the historical school, and the division between the Romanists and the Germanists reproduced all over Western world as a way of organizing universities and law schools. Chairs of Roman law established in most Western universities, and chairs of legal histories often accompany the national epithet Spanish, Swedish, or French. So you have this Roman chair, and you also have, for example, the Spanish legal history chair. So there are two contrasting fields, both simultaneously historical, and founded to continue the Germanist line of research, but not Germanists in Germany specifically, but in terms of the context of their own respective states. Historical school played a decisive role across the continent, although the ways in which interests converted into disciplines differed. France came first with the primary task to create a national legal history on the basis of the Napoleonic codes and the reorganization of the state after the Revolution. In Sweden, most scholarship was influenced through the Savigny School. The first chair in legal history that was established there in 1835, and from 1866 onwards at the University of Uppsala with Roman law, legal history, and the legal encyclopedia came to cover both Romanist and Germanist orientations. Hungary's main university at the time, Eötvös Loránd in Budapest, had its first legal chair in history, titled The History of Law and State, was established in 1855, and the first chair in Hungarian legal history in 1872. In Spain, it was connected with works of Eduardo de Hinojosa, and he established the Centro de Estudios Históricos, so Center of Historical Studies, in 1910, and Anuario del Derecho Español in 1924. In the Baltic provinces of the Russian Empire, legal historians produced their scholarship as professors of private law and Roman law, so private law being likely the domestic history, or provincial laws, and chairs of legal history as an independent subject had to wait until the 20th century. So a little bit lagged behind in Russia, the Baltic provinces, but nonetheless across all these civil law jurisdictions, legal history in two streams, both the Romanist stream and also the domestic streams, particularly as we might call it, Germanist, manifested clearly. In many cases, the impact of the historical school fell short of what Savigny would have likely wished. Frederick George von Buge, a towering figure in the Baltic legal scholarship, and follower, at least in principle, of Savigny, in practice constructed the famed Baltic Civil Code on the basis of empirical studies on contemporary jurisprudence, not history. So, although they are building these codes, they might not have been doing so in such a way that, or such a historical approach as Savigny would have liked, or had wished. Much can be said of most other continental countries as well. The heritage of historical school nevertheless persisted in the Continental law faculty curricula, and history was, and has been ever since, considered essential for the self-understanding of an educated jurist. So, since history has been pretty much ingrained of a self-understanding educated jurist in this civil law context. Emancipation of legal history also meant its raison d'etre, or reason to be, changed, and it no longer based its existence on providing overall ancient legitimization or concrete sources for contemporary law. Historically interested Ius Modernis scholars had done the former. Historical school had done both. The late 19th and early 20th centuries, with radically changing political systems of European continent and countries culturally close to it, and the democratization as well on its ways, and closely linked its supremacy to parliamentary statutes as a legal source. The 19th century also was a decisive period of legal modernization, in what Max Weber called the rationalization of Western law. For Savigny and the Romanists, or Pandectists, legal history per se was not central. Instead, it provided materials for systematizing the law of the 19th century. Unlike representatives of Ius Modernis, and not interested in building direct historical continuum with the Romanists built directly on ancient law, Romanticism of the historical school was less typical for Romanists than for the Germanist branch of historical school, and representatives of which needed to build their teaching on a more heterogeneous array of medieval law. So despite this, there is these two forces. However, there is much intertwinedness between the two, and also heterogeneous sources. There's not just one Roman law, there's not just one domestic law, and there's not just one place for each. And also, history was not always present as well, or at least not in the humanist stream or Savigny's stream. Despite the large impact of the German legal scholarship, Germany's dispersed political structure protracted statutory development that could only start after reunification in 1871. So their legal history therefore remained in service of legal science longer than in many other parts of the continent. So because Germany was divided and only got unified in 1871, its period of historicizing was longer. So perhaps other countries had ended earlier. The Civil Code started the process in France, where in 1807 Napoleon founded a professional chair on the history of legislation, which was to be responsible for presenting a tableau of various civil criminal codes, political institutions, and public law adopted successively by other people down to the Napoleonic Code. In this climate, with new fields of law toward the ends of society, the best legal history could do was to accommodate. This was legal history of modern state par excellence, based on evolutionary historicist idea of law as something which was culturally and socially contingent. So probably the heyday of history was in the establishment of the French Civil Code, which was initiated, the process was by Napoleon, but however it wasn't a purely a humanist approach, as it did have specific purposes and a specific vision. However, nonetheless, it was perhaps a heyday for history, whereas in Germany, because the Civil Code was not completed until 1900, it had a perhaps much longer period of historicism. Although national histories and legal history, according to the author, dominated the 19th century, they're not the full story. Following Hegel's philosophy of history, Edward Gans was the first to publish a work on a universal legal history, Das Urrecht in Welgenschnittler, and Wickelung, published in 1834. Joseph Unger's book on universal history of marriage law followed this model. So these two endeavored to create universal histories as opposed to histories based on each geography. Joseph Unger in the specifically in marriage, but Edward Gans perhaps covering a universal legal history, very ambitious projects. But the idea of universal history was somewhat revived in the 20th century, not least due to the impact of Oswald Spengler and Arnold Toynbee's universalizing history writing. None of these, however, posed a great threat to the prevailing paradigm of national legal history, which is still quite fragmented. Universalism was, however, barely reflected in legal history at that point, with the curious exception of William Segal's Quest for Law, published in 1941. Which moves us to the last section, section 5, or should be section 6. I think there was a little bit of an error in the, not in mine, but in perhaps the author's ordering of the numbers, but maybe it is perhaps. Nonetheless, the last section is section 5, the present and future of legal history. But it's actually section 6 of the book. But of the chapter, nonetheless, as we've seen, there was many domestic at the civil level legal histories, as well as the Romanist, to varying degrees of influence. But as well, there was an endeavors to create a universal legal history, but it never fully manifested, perhaps because the project is too grand. One might focus just on marriage law, as we saw one did, but it was perhaps too ambitious. Nonetheless, after World War II, new methodological alternatives started to appear on the scene of the continental legal history. Three tendencies simultaneously in part characterize post-World War II legal history. First, the prevailing paradigm of national positivism was starting to appear less and less satisfactory. So national positivism, taken to the extreme in Nazi Germany, was less satisfactory. The national boundaries were no longer the most obvious frameworks for study. First, because the shifting of the boundaries during the war, but also with the coming of the League of Nations, or the United Nations. The League of Nations was between the two worlds, the United Nations and later European Union as well. And they were surely connected to post-war critique against legal positivism in general, and the transnational legal history gained momentum with US Commune in works by the Italian Francesco Calesso and Germans Paul Koschacker, Franz Wiesacker, and Helmut Koenig. And the backdrop of the European unity, the coming of the European Union, led to the foundation of the Max Planck Institute for European Legal History in Frankfurt in 1964, so legal history generally across all of Europe. And the achievement of Reinhard Zimmermann's and Manilio's Bellomo's are monuments of the school. They came to include more tracts of the continent, including Nordic countries, Eastern Europe, and even Iberian Peninsula, and followed the expansion of Europe as a political entity. So the coming of the European Union and the end of the Second World War led to not only a more unified histories, but also to include some of these smaller regions or areas or countries that had not previously had their own distinct legal histories or as prominent as such. And the temporal emphasis of legal history shifted from national models of Roman models to private law or more general concepts like private law. So by taking a more specific focus, they could broaden their geographic base. And politics as well had an impact, and critical legal studies from American movement closely followed in many parts of Europe, particularly in Scandinavia, and expanded the scope of with which Morton J. Horowitz and Robert Gordon were leading this change. The archival studies and social sciences spread fast too, so better methods of social science, but also better archival methods and documentation led to quicker spread of legal history in continental Europe, and not amount to a new common approach or methodological revolution anywhere on the continent, rather a loss in faith in master narratives. Dogmengeschichte was still alive. Dogmatism essentially was still alive and well. Was particularly amongst conservatives, but as we've seen, according to Marcus Dubber's excellent chapter, and also as evidenced through this entire textbook, the civil law countries have been moving to interdisciplinary, so these conservatives might be becoming at least, if not less numerous, but less powerful as schools become more interdisciplinary. In addition to the demand for national legal histories arose in nations which were previously behind the Iron Curtain. During the 21st century, new set trends towards comparative, global, and transnational legal histories also came forward, and despite the exceptions, it seems that methodological reforms have advanced more rapidly in small countries such as Belgium, the Netherlands, the Nordic countries, and it does not make sense for each to draft anew and break with the national orientation at the end of the Cold War and the expansion of the European Union. There's also this trend of the coming of the International Society, where the European Society for Comparative Legal History with the journal Comparative Legal History was founded in 2010 and 2013 respectively, and the modern universal global history giants such as Emmanuel Wallerstein and Fernand Braudel have left earlier universal historians with optimism. So they're taking on very challenging projects of amalgamating many different historical works or across different geographies and across different dimensions as well, not just in the private sector or not just in the public or private law, public law, but across all sectors and across all geographies. Too much perhaps for one to do, but perhaps by working together they can. Global legal history seems possible if European legal histories are possible, according to the author, while globalizing tendencies in law in fields such as mercantile law, constitutional law, procedural law, and human rights law show promise, must look beyond the Eurocentric or Western-centric focus by considering other nations, such as Chinese legal history and African legal history, and different from colonial legal history, and differences in comparative European, global, and transnational legal histories also exist, but this distinction perhaps is moot. Why not all legal histories, as are dimensions of public, international, criminal, and procedural law? All epochs, all subjects, all geographical areas are present at the same time, while a huge synthesis still awaits its author. So still much to do, and also perhaps even this chapter, while focused on continental Europe, why not include even the common law as well in one grand narrative? Perhaps it's too ambitious, but perhaps it can be done after the work, after the groundwork. They say standing on the shoulders of giants, perhaps. Does legal history, he ends with this last quote, does legal history gain in importance as the pace of legal change accelerates? It is simple to answer this question affirmatively. Modern legal history, more than anything, is about explaining legal change in its cultural, political, social, and transnational contexts. If those changes multiply, the need for scholarly explanations increases as well. So it's not that the more work that is done, there will be less to be done. So the more that is uncovered, the more that becomes to be done. So it is kind of exponential. So I think a nice, beautiful way to end it. So that is the chapter located in the Oxford Handbook of Legal History, Section 4, Traditions Tracing Legal History, Chapter 38, Tracing Legal History in Continental Civil Law, by Dr. Heikki Pihlajamäki from Finland, the University of Helsinki. Great legal scholar there, legal historical scholar. So the content of the slide. His institution is the University of Helsinki, where he's the Academy Professor and Professor of Law. His research interests include modern colonial laws, Middle Ages and early modern context of European continental empires, legal orders, and comparative methods. The suggested readings include the Oxford Handbook of European Legal History, where he is an editor alongside the editor of the Oxford Handbook of Legal History, Marcus Dubber, and Godfrey is the other, M. Godfrey, published by, as you may guess, the Oxford University Press in 2018. Next book, Understanding the Sources of Early Modern and Modern Commercial Law, Courts, Statutes, Contracts, and Legal Scholarship, where he's an editor with Cordes, Duchy, and de Richer, published by Brill Nijhoff in 2018 as well. And his third book suggested here, among 18, he has either edited or written, A Case of Legal Pluralism in Early Modern Europe, published by Brill Nijhoff in 2017. So another reason why I think he was excellent to write this chapter on continental Europe is he was a leading editor of the Oxford Handbook of European Legal History. So nonetheless, and this is once again probably the best history you can get of civil law, because these are all civil law countries, and it's also the one that most manifestly evidences it, or most specifically focused on it, and it also contrasts our previous chapter on common law most perfectly. So
As for the logos, we have the University de Belagro in Buenos Aires, where he was a visiting scholar. Above that, we have the University of Tartu in Estonia, where he was a visiting professor. And in the top left, we have the University of Helsinki, where he has received his doctorate, his Masters of Law, and his licentiate in law, and is also currently a professor, academy professor, and professor of law. Moving to the three quotes I have collected here. First legal humanists of this first quote, legal humanists of the 16th century were the first legal scholars specifically interested in the history of law. Ancient Roman jurists were too practical-minded to care for legal history. Next quote, methodologically, the representatives of the historical school were the first professional legal historians in the modern sense of the term. However, their method was intimately linked to the emerging science of law, Rechtswissenschaft, and was not an independent discipline as legal history is today. And third quote, modern legal history, more than anything, is about explaining legal change in its cultural, political, social, and transnational context. If those changes multiply, the need for scholarly explanation increases as well. So I hope you enjoyed and learned as much from that chapter as I did. And now we will move to the comparison in the style of Plutarch's Lives. Let the sun in. I can read this. Nice. Okay, moving to the comparison. So, between Kunal M. Parker and Heikki Pihlajamäki, both are doctors, both have PhDs, but one thing that might be noted is that while Pihlajamäki's doctor isn't a doctor of law, Parker's degree is a doctor of history from Princeton and or from University of Helsinki and Princeton respectively. So, but nonetheless, Parker did study in the United States, where Juris Doctor is technically a Juris Doctorate, but there is the SJD, which is the more formally recognized Doctor of Judicial Sciences. They are both lawyers, and they both have master's degrees in law, however. However, Kunal M. Parker received his in the United States, where he did a few years at Dartmouth before moving to Harvard, where he received his Bachelor of Arts and his Juris Doctor, and Princeton, where he received his PhD, whereas Pihlajamäki received all of his degrees, as far as I could find, from the University of Helsinki. So obviously two very different countries, different continents as well, and very different areas of study. One was studying almost entirely in a civil law jurisdiction, one was entirely in a common law jurisdiction. They both have many academic, whereas Parker has many academic, perhaps maybe more academic fellowships than Pihlajamäki. Pihlajamäki, as far as I can see, had a longer, more extensive legal career, where he was a legal officer for the Office of the Parliamentary Ombudsman, and he was also a clerk for the lower court. But he's also been a visiting scholar and a visiting professor as well. However, although perhaps I could not find it on Dr. Parker's CV, he has passed the New York bar in the second department, so maybe he has spent some time practicing. I just could not locate much on that. But nonetheless, they're both very distinguished academic careers. Their interests do differ in that Kunal M. Parker is more focused on immigration, property, race, U.S. history, constitutional law, estates and trusts, conflicts of law, whereas Pihlajamäki is more focused on the colonial experience, linking the colonial experience of the Middle Ages and the continental European empires. And to that I might add that Pihlajamäki is a general interest in European legal history, as he was an editor of the Oxford Handbook of European Legal History, but as we saw in his conclusion, he's also interested in legal history broadly, whereas I think that is true of Kunal M. Parker, where he is fascinated in legal history, but perhaps more focused on at least the American context. His chapter was focused on common law, where he did address much about the United Kingdom, but it was less of an indication that he has much interest in civil law legal history. In terms of books, not that like this is some competition, but it's important just to note the differences, as
in Plutarch's Parallel Lives, he does take a very critical approach to all he writes about. But I have absolute respect for both of these, but both of these scholars and all the other scholars in the Oxford Handbook of Legal History. But nonetheless, Kunal M. Parker has yet produced 2 books, whereas Heikki Pihlajamäki has either edited or written 18 books. So a difference in the number, but it could be more dependent on their time spent in academia, or in time spent or time available to write. But furthermore, the number does not also indicate quality as well. And Kunal Parker also has countless papers and over 31 articles. But Pihlajamäki does have some award-winning article, and he has been nominated for a top professor and has won top professor awards, whereas Kunal M. Parker, but perhaps because he is still yet to win one of these awards, or perhaps the nature of the university he works at is less likely to win these awards, or it's all circumstances, but nonetheless these are distinctions that should be made. In terms of languages, Dr. Kunal M. Parker is competent in French, German, Hindi, Marathi, and Spanish, and evidently English as well, so which makes him a polyglot, whereas the same information could not be found for Heikki Pihlajamäki, but I'm certain he speaks Finnish, having spent so much time in Finland and the University of Finland, and as well he might speak some Spanish, having been a visiting scholar at the University of Buenos Aires, so English, Finnish, perhaps Spanish. I mean, he also was a visiting professor at the University of Estonia, and I might be wrong, but I'm pretty sure Estonian is its own language, or at least has a language for the region, so that could be a 4th language, so on polyglot territory as well, perhaps. And maybe he speaks many other languages that just wasn't necessarily listed in the way it was for Kunal M. Parker, who is undoubtedly a polyglot. But nonetheless, I think these 2 individuals, although they have 2 very particularly contrasting chapters, at least in the course of this series that I produced, and I will also, not to go on a tangent here, but this is the 10th from the last video. I was going to mention this at the beginning, but I forgot to, so almost there, and this has been a very challenging but rewarding experience, and I've learned so much. And if you've made it this far, or this is your first video, I hope you already feel good for having made it through at least this video, or this far, or through all the other videos. I know personally I've really improved, but nonetheless these 2 individuals are more similar than they are different, in that they're both similar to me, in that they're also fascinated in legal history, and hence, while they may have differed in many ways that I previously mentioned, they are more alike compared to most other legal scholars, or most other scholars generally, or most other even non-scholars, in that not only are they scholars, not only are they doctors, they're also interested in legal history. Whereas one may come from a common law and write on common law, and one may come from civil law jurisdiction and write on civil law, they are both have similar fascinations. And if they had been born in alternate places, perhaps they might have even fulfilled each other's shoes. So, without further ado, I hope you enjoyed this very much. My name is Kalen Ashcroft, this is CashcroftTV, and I hope you enjoyed this video on the Guide to Legal History and Historians. Thank you so much. I hope you continue to support them.